The timing of written statements is also important, and this is particularly for pre-hearing written statements. And this is something which will be determined right from the outset at the preliminary conference or at the case management conference, and there might be changes to the schedule as the proceedings continue. The tribunal, along with the parties, will set out a provisional timetable which will determine the dates for submission. So generally speaking, a date for the hearing will be set out at some point in the future, and then backing up the time for the different submissions, if there are any evidentiary hearings, and anything else will then be determined based on that, and a schedule or a timetable will be set forth. Now, the periods of time allowed for different submissions may be more general or more specific in the rules that are applicable to the arbitration. Article 25 of the rules, for example, sets forth a period of 45 days. Other institutional rules might actually set forth the number of days after the notice of arbitration for the response, for the statement of claim, defense, etc.
How the New York Convention works, as I mentioned already, it contains two pieces. One, the obligation to stay litigation, and the other, the obligation to enforce awards from other convention states. So the obligation to stay litigation in breach of the arbitration agreement exists unless one of these two grounds for resisting a stay exists. The dispute is not capable of settlement by arbitration. The other is where the arbitration agreement is void, inoperative, or incapable of being performed. So if the arbitration agreement is pathological, it contains provisions that just don't make sense and do not evidence a clear submission to arbitration, then the court may find that actually it's not a valid arbitration agreement, and the proceedings default back to the local courts. And in that situation, it would be possible for the local court to resist a stay.
There are two main traditions of mediation. The first is what I might call the intuitive, informal, traditional form of mediation, which has been around forever, since the beginning of humankind. And the second is a more recent phenomenon, and it is what I would call a professionalized, increasingly regulated form of mediation, which really came out of the ADR movement, which began in the United States in the 1970s, took hold in common law countries initially, and then also in civil law countries, and now is a worldwide phenomenon. Now, in this course, I will be focusing on professional mediation, but I just want to say a few words about the intuitive traditional form of mediation and its differences and similarities compared to professional or modern contemporary mediation, if you like.